the mic system. Thank you.
हीरे मोती मेरे देश की धरती मन धड़काए बदरवा मन धड़काए बदरवा काले मेघा पानी तो बरसा लाए मेघा छाए बरखा लाए गिर गिर आए गिर के आए
ह्याचा पण काय हालत आहे ना. आपण आता तुमचा इंटरव्ह्यू करू रिस्टार्ट नॅशनल
Guys, you know what? What? Our school, Army Public School, KIRKEE is organizing Ethics Bowl this time.
Our school.
Yes, our school. Ethics Bowl? What is it? Is it a debate or something? No, it isn't a debate. Ethics Bowl is a competition in which two teams discuss about ethical dilemmas and try to come up with the best possible solution. That's really unique. Shall we go and see? Yes, let's all go and see.
Let's go. Army Public School KIRKEE presents to you Ethics Bowl 2020.
May I request children to kindly maintain the decorum of the event? There'll be an alarm at the time when our chief guest arrives. I request everyone to kindly rise.
Is it a good thing that the jury got abolished? I
Of
mean,
course not.
good thing it got abolished. I mean, no.
I do have strong opinions on this topic, but how do I express this? I mean,
Are you also not able to speak in public? Are you underconfident? Are you the log kya kahenge wala guy?
Well, not anymore because our Southern Command is organizing an ethics bowl competition. Here, students from all over the country come and compete. They present their views on the most ethical topics that are important to the world. Then see you at APS KIRKEE. Peace out.
Army Public School KIRKEE presents to you Ethics Bowl 2022. Raise your words, not your voice.
Hey, do you remember that Nanavati case? I do. वही जैसे रुस्तम इंस्पायर वही So what do you think? Was it a good thing that the jury got abolished? I
Of
mean,
course not.
good thing it got abolished. I mean, no.
I do have strong opinions on this topic, but how do I express this? I mean,
Are you also not able to speak in public? Are you underconfident? Are you the log kya kahenge wala guy?
Well, not anymore because our Southern Command is organizing an ethics bowl competition. Here, students from all over the country come and compete. They present their views on the most ethical topics that are important to the world. Then see you at APS KIRKEE. Peace out.
Army Public School KIRKEE presents to you Ethics Bowl 2022. Raise your words, not your voice.
Good morning. May I request everyone to kindly keep their phones on silent mode?
Check. Mic check. Check.
Check, check.
In the words of famous philosopher Socrates, it's not living that matters, but living rightly.
Greetings to the august gathering. On behalf of the management, principal, and staff of Army Public School KIRKEE, we welcome Mrs. Anita Nain, Regional President, AVA Southern Star. We welcome Mrs. Anita Walia, Regional Vice President, AVA Southern Star. We also welcome Mrs. Aarti Jaldial, President, Chairperson Schools, Southern Star, our respected judges, and dear participants.
We would also like to extend a warm welcome to the senior officials of SBI. We welcome Major General MMS Bharaj, retired, Circle Defense Banking Advisor, Maharashtra, Gujarat and Goa. We also welcome Mr. Jagannath Sahu, Deputy General Manager, SBI, AO Pune, and Mr. Pankaj Kumar Singh, Regional Manager, SBI. A special welcome to Mr. Naresh Unhale, Manager SBI, BG and Center.
Ethics is a code of values which guide our choices and actions and determine the purpose and course of our lives.
We have always been confused with the question, what we have a right to do and what should be rightly done. Even great scientists like Albert Einstein once stated that without an ethical culture, there is no salvation for humanity.
Wait a minute, Medhika. I have been noticing that you have been emphasizing a lot on ethics, ethical culture, and all. Don't tell me that you're here to give me a lecture on that.
Oh, Shubhayu, no way. Haven't you heard about Ethics Bowl?
Ethics poll. What's that? A debate or an elocution?
No, not at all. An ethics bowl differs from a speech and debate competition in that students are not assigned opposing views. Rather, they defend the position they actually hold or think is reasonable, provide each other with constructive criticism, and win by demonstrating that they have thought rigorously and systematically about the cases and engaged respectfully and supportively with all the participants. It is designed to get students thinking, talking, and ultimately working together on some of the toughest moral issues of our times.
Oh wow, that is so unique and interesting. So, I assume we're here for that, right?
Yes, of course. But before we begin this much awaited moment, let us seek the blessings of the Almighty for each task we undertake. We need to spread the divinity of knowledge so that every mind is illuminated and every path is clear. Vakratunda Mahakaya Suryakoti Samaprabha Nirvignam Kurume Deva Sarvakaryeshu Sarvada.
Let's pray to the Vignaharta to bless us and help us overcome every obstacle in our path. We now present the Ganesh Vandana by the students of Army Public School KIRKEE, invoking the blessings of the Almighty. Thank you. That really gave us a positive spirit to start today's event.
शहीदों की चिताओं पर लगेंगे हर बरस मेले, शहीदों की चिताओं पर लगेंगे हर बरस मेले, वतन पे मिटने वालों का बाकी यही निशान होगा.
Now we have Army Public School Diggi's choir paying tribute to our martyrs through their melodious rendition.
भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम. रुक ना पाए तूफानों में, रुक ना पाए तूफानों में, सबके आगे बड़े कदम, जीवन पुष्प चढ़ाने निकले माता के चरणों में हम. भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम. समस्तक बरहि में राज विराजित उन्नत माता, माता का चरण धो रहा विशाल सागर, देखिए ही सुंदरता का. हरियाली साड़ी पहने माँ, गीत तुम्हारे गाए हम, गीत तुम्हारे गाए हम. भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम, भारत वंदे मातरम, जय भारत वंदे मातरम. शुभ्र ज्योत्स्ना पुलकित यामिनी, कुसुमिता ध्रुमानय शोभिनी, सुहासिनी, सुमधुर भाषिणी, सुखदां वरदां मातरम, वंदे मातरम, वंदे मातरम, वंदे मातरम.
Thank you. Please give the students of Army Public School Diggy a big round of applause. As it is rightly said and quoted by Warren Bennis, leadership is the capacity to translate vision into reality.
Our chief guest for today, Mrs. Anita Nain, is an educationist par excellence who has mentored and groomed students in her teaching career for over 20 years. When it comes to gardening, we think of the bloom of spring. We think of the aroma of flowers. And when it comes to Mrs. Anita Nain, her passion for gardening is reflected in her beautiful persona. May I now request Mrs. Nain to address the audience. I would also like to request Mrs. Aarti Sharma, Principal of Army Public School, KIRKEE, to kindly accompany Mrs. Nain.
Good morning, dear students, principals, teachers, ladies and gentlemen. एक विचार हमने रखा, एक विचार आपने रखा। सहजता से हुआ विचारों का आदान प्रदान, सही गलत का हुआ समाधान। यही तो है नीति शास्त्र, नैतिकता से सही निर्णय लेने की प्रतिक्रिया। Ethics tones the mind and soul. It's beyond arguments. Ethics is learning life skills and preparing one for a successful life. My compliments to all the principals, teachers, and students for making Ethic Bowl and our initiative a success. Dear students, I know you all have done a lot of practice, preparations, and hard work to get this far. My best wishes. Give your best and you will be great. Our judges for today are professionals in their respective fields. It would be interesting to listen to their questions and to see what inputs they have on our students' presentations. Good luck to both the teams. Thank you. Jai Hind.
Thank you, ma'am. As you rightly said, ethics is learning life skills and preparing one for a successful life. We completely agree with you.
I'm sure each one of us must have got inspired by your words of wisdom. The stage is set, the mic check is over. As hearts beat fast and excitement grows, it would be unfair to keep you all waiting on the edges of your seats, anticipating what would happen next. Without further ado, I would like to introduce the finalists of Ethics Bowl 2022 competition. Team D, and the participants are
Samyukta Sharma, an all-rounder who's enthusiastic in coding, sports, singing, and science.
Daksh Bhatt, a keen enthusiast in the world of geopolitics and current affairs.
Bhumi Arora, she's an enthusiast who lives by the motto, enjoying life as it comes.
Niharika Sharma, an eager public speaker who has participated in various competitions like mock parliaments, MUNs, etc.
Anushka, a public speaker and a keen debater.
Agastya Chaturvedi, another all-rounder who has always made his school proud.
Please give it up for Team D.
ई से करवाते हैं। समूह ई के सदस्य हैं
अश्मित, इन्हें व्यवसाय प्रबंधन में अधिक रुचि है। नेतृत्व क्षमता, संगठन प्रबंधन जैसे गुण इनमें कूट कूट कर भरे हुए हैं।
हनोक, इनकी रुचि गीत संगीत, वाद्य यंत्र और कविता लेखन में है।
अद्वित, इनकी रुचि गीत संगीत, क्रिकेट एवं विज्ञान में है। इन्हें राष्ट्रीय स्तर प्रश्नोत्तरी प्रतियोगिता में उप विजेता घोषित किया गया था।
नंदिनी, इनकी भाषा पे अच्छी पकड़ है। समूह नियोजन, समूह कार्य में इन्हें महारत हासिल है।
सानवी, ये एक अच्छी लेखक, कवयित्री एवं तैराक हैं।
एकता, ये एक सृजनात्मक प्रतियोगी, आत्मविश्वासी खिलाड़ी, कुशल वक्ता आदि अनेक गुणों से युक्त हैं। आप सभी को प्रतियोगिता की हार्दिक शुभकामनाएं।
Our dynamic teacher, Mrs. Poonam Thakur, will be the moderator for today's event. A few words introducing this dear and wonderful teacher of Army Public School, KIRKEE.
Mrs. Poonam Thakur has a teaching career spanning over 21 years. She has been mentoring meritorious students in Army Public School, KIRKEE for the last 7 years. She's a content developer and has her own YouTube channel. She has prepared many students for various debates, declamations, and other competitions. Poonam ma'am has been there with us since the beginning of this Ethics Bowl competition. She's very passionate about teaching and loves to support and guide her students.
Let me introduce you to our esteemed judges for today's event. Today, we have with us one of the leading lights of Pune who has contributed immensely to the betterment of people in our city. Today, it's an honor to welcome Mrs. Pooja Manish Anand, an eminent politician and an active member of the KIRKEE Cantonment Board. Being a multifaceted personality, Mrs. Anand is widely recognized for her work in philanthropy, social welfare, women empowerment, and environment conservation. In recognition of her immensely effective social work, various organizations have felicitated her with many prestigious awards. We welcome you, ma'am.
प्रकृति प्रेमी, अध्यात्म में रुचि, कानून में इनके ज्ञान की गहराई का कोई अंदाजा नहीं। परिचय क्या दूं मैं इनका, ये किसी परिचय के मोहताज नहीं। यह अत्यंत प्रसन्नता की बात है कि आज हमारे बीच सम्माननीय अधिवक्ता शैलेंद्र आगलावे जी हैं। एक वकील के रूप में विभिन्न क्षेत्रों में आपको कार्य करने का लंबा अनुभव रहा है। मान्यवर, मैं तहे दिल से आपको धन्यवाद देना चाहूंगा और मुझे पूरा विश्वास है कि आपके द्वारा किए गए 13 जुलाई 2022 और आज के मार्गदर्शन से सभी अवश्य लाभान्वित होंगे। महोदय, आपका बहुत बहुत स्वागत है।
Our next judge for the event, Dr. Pranay Oswal, is the founder and managing director of iCube LLP. Dr. Oswal is a chamber member of the Maharashtra Chamber of Commerce, Industries and Agriculture. Dr. Oswal is also a member of the Association for Primary Education and Research and the Indo-American Chamber of Commerce. Dr. Pranay is a self-driven and a seasoned professional. He co-pioneered the Intelligence Quotient Olympiad examination, incorporating 75,000 K-12 students in over 300 schools across all boards in India. Thank you so much, Dr. Oswal, for being here with us today to enlighten us with your wisdom and experience.
On that note, let us take you into the final match of Southern Command Ethics Bowl Competition 2022, organized by Army Public School, KIRKEE.
मैं श्रीमती अनीता नैन महोदया से आग्रह करता हूं कि वे प्रतियोगिता आरंभ करने की अनुमति दें। महोदय, प्रतियोगिता आरंभ करने की अनुमति है। धन्यवाद महोदय।
I request the moderator to kindly take over the event from here. Thank you.
Children. A very warm good morning, everyone. Welcome to the finale of the Southern Command Ethics Bowl Competition 2022. Army Public School KIRKEE organized the Southern Command Ethics Bowl Competition from 13 July to 18 July under the aegis of Army Vice Welfare Association Southern Command. Mrs. Anita Nain, Regional President AVA Southern Star, Mrs. Anita Walia, Vice President AVA Southern Star, and Mrs. Aarti Jandial, Chairperson Schools AVA Southern Star, acted as the main guiding light for the planning and execution of Ethics Ball 2022. APS KIRKEE began its preparation 2 weeks prior to the competition. Various committees involving teachers and students were formed to cover the different aspects of the competition and smooth conduct of the event under the able guidance of Principal Aarti Sharma. Since the competition was conducted online, students and the technical team played a vital role and all the matches were streamed live on YouTube. The event was given wild publicity on social media. The teams which qualified the cluster level competition competed against each other during a week-long event. The competition commenced on July 13 at APS KIRKEE and was virtually participated by APS Sagar, APS Bangalore Kamraj Road, APS Jodhpur, APS Mumbai, and APS Golconda. The competition was held in a round-robin format in which each team competed with every other team. Children were judged on the clarity in addressing the central ethical dilemma, awareness, thoughtful consideration of opposing ideas, and most importantly, they engaged in respectful dialogue. Team D and Team E, with maximum wins, have proved their mettle and have qualified for the finals of Southern Command Ethics Ball competition. The winners of today's match will be representing Southern Command at national level. I would like to thank Mrs. Anita Nain, Regional President, Ava Southern Star, respected dignitaries and our esteemed judges for taking time out from their busy schedules. On behalf of Army Public School, I welcome you all. As it is rightly said, and I quote, "The difference between the moral dilemma and ethical one is that in moral issues, the choice is between right and wrong. In ethics, the choice is between two rights." On this note, let's commence today's match. All the best teams. Before we start, I would like to read out the rules and regulations for the rounds. I, as a moderator, will be introducing the case for the benefit of the audience. Both the teams will get 10 to 12 minutes to present their commentary, basically answering the ethical question put up by the moderator at the end of the case study. Reminder alarm will sound after 10 minutes and 12 minutes. After that, 2 marks will be deducted for exceeding the time limit. Team E will be given 2 to 3 minutes to confer post Team D's presentation and present their viewpoint on the ethical question lasting 5 to 7 minutes. They may agree or disagree to their viewpoint. In either case, they need to give their reasons. You are required to ask maximum of 2 questions to the opposite team. Team D will be given 2 to 3 minutes to confer and come back with their answers. No cross-questionings by Team E is allowed. Team D will be given another 5 to 7 minutes to answer the questions posed by the opponent team, that is Team E. Post Team D's and Team E's presentation, moderator will request the judges to ask 1 question each. Judges are allowed to cross-question the students. Once the judges' round is over, a break for 10 to 15 minutes will be declared before Team E present its commentary. Once Team E starts, the same format will be repeated. Teams, as you know, from this point on, there are no substitutes or consulting with anyone other than your teammates at the table. Reviewing outside material is not allowed. Coaches and audiences, please remember that communicating with either team verbally or non-verbally is not permitted. Please remain quiet throughout the competition so that the students can concentrate. Now I request everyone present here to put their phones on silent mode. Thank you, everyone. I hope the rules and format is clear to all the participants. Thank you, teams. Okay, Team D, you will present first. Judges, please note on your score sheet that team presenting first is Team D and team going second is Team E. Although the case studies were shared with the teams and the judges 18 hours prior to the match, I shall read the case study for the benefit of the audience. Team D, the case study we are going to discuss is medical negligence. So here I go.
Dinesh Jaiswal was taken into emergency surgery, impending gangrene. However, the night after the surgery, the nurse attending to him observed that his lower limbs had gone cold and he was unconscious. The doctor was called at 4 a.m., but he came at 9:30 a.m. A decision was taken to re-explore the surgery, but all operation theaters were occupied, delaying his surgery by 12 hours. Afterwards, the lead doctor went on a foreign visit. His heirs filed a case of medical negligence against the doctors. The court held no doctor can assure life to his patient, but can only attempt to treat his patient to the best of his ability, which was being done in the present case as well. Now, Team D, my ethical questions to you are, listen carefully. Did the doctors treat Dinesh to the best of his ability? Does negligence in context of medical profession call for treatment with a difference? Question number 2. In view of the above question, is professional negligence different from occupational negligence? I hope questions are clear.
Yes, ma'am.
Okay.
Yes, ma'am.
Team D, you have 12 minutes to make your presentation and your time starts now. All the best.
Thank you so much, ma'am, for clearly explaining the given case study. A very good morning, respected judges, respected teachers, honorable dignitaries, and my dear friends. Today, Team D would like to present their views on the given case study. None of us can deny the fact that the medical profession is the most noble profession. Have we wondered why? It is because it helps in preserving and sustaining the human life. None of us can deny the fact that as human beings, the greatest deed one can do is to save another human life. The entire medical profession is based on two major principles. First is to maximize your potential and give in your everything to save the patient's life. And secondly, to inflict no harm to the patient intentionally because of your recklessness, carelessness, or your medical negligence. Although it is logically not feasible for the doctor to save every patient's life, but it is important to ensure that the doctor and the institution concerned give in their best and try their best to save the patient's life.
A great man is different from an eminent man. Why? It is because he chooses to serve society. A patient approaching a doctor has intentions of going to the doctor with intentions of curing himself and seeking any kind of medical help that he needs, any kind of issue that is concerning him, and the doctor has a duty. It's his moral obligation under the Hippocratic Oath to help him. Thus, there is a relationship between these people. It is like a contract, and it has all the essential elements of a tort. And it is a moral duty again of the doctor towards the patient. Now, when the doctor fails in delivering his duty, he becomes negligent. Negligence is carelessness, laxity, and it is the deviation of one's duty to a completely different level, and it is the breaching of the duty.
It is a tort, yes, and not a very common one at that. Medical negligence is defined as the event where a doctor or a professional neglects his duties towards his patient in the medical field. Every year, 52 lakh people are injured because of medical related injuries. And out of these, 98,000 people lose their lives every year. Why? Because of medical negligence.
While filing a suit against the doctor, it is the plaintiff, that is the patient's responsibility to prove the negligence done by the doctor, that this negligence resulted in pain, suffering, and injury to the person. For this, the plaintiff requires to have enough evidence,
to file a civil case for compensation and as a writ under the Article 226 of the Constitution. Moreover, when a doctor enters the world of medical science, there is a term which is called implied undertaking. This means that the doctor has to serve the patients rationally and skillfully throughout his career.
There are three essential elements when it comes to negligence. One being that the defendant had a duty towards the plaintiff. The second, that the duty towards the plaintiff was breached. And third, that the plaintiff had to undergo harm because of the negligence of the person. Now, we know a lot about negligence, but there are different types of negligence, as is given in the case study too. We know businessmen, we know professionals, we know manufacturers. They are amazing at their jobs. They have the skills that are required and they have the knowledge about it. That is what makes them professionals. And when a professional neglects his duty, it is called professional negligence. Professional negligence is when he deviates from what is his moral responsibility to something that is not moral or ethically acceptable at his position. Negligence is a big area of law to deal with. But before we talk about professional negligence, let us understand the difference between profession and occupation. I know most of us do use these two terms interchangeably in our daily lives, but it is important to understand.
Please adjust your mic.
But it is important to understand the difference between them. Occupation refers to the regular activity you have been doing on a daily basis to earn your daily bread and butter. It deals with your ability. However, profession is something which you do out of your qualification and your passion for that particular activity. It also deals with your eligibility. And therefore, professional negligence is much more dire than occupational negligence.
Let us now take a look at the case of Harijit Ahluwalia versus the Sun Meadow Hospital. In this case, the minor Harijit filed a petition against the hospital on behalf of his parents, through his parents. He alleged that in December 1993, he was being treated in a nursing home in Noida. And according to his complaint, due to the negligence of the hospital staff...
Adjust your mic. Adjust your mic. Yes.
Ma'am, is it fine now?
Yes.
Thank you, ma'am. And due to the negligence of the hospital staff, he suffered from irreplaceable injuries and a vegetative state. The injuries which were caused to him due to this negligence has doomed his life forever. He fought his case and won a compensation of 28 lakh rupees.
Negligence is the offense under tort, under Article 304A, the Consumer Protection Act, the Indian Contracts Act, and so many more. And it even violates the fundamental right to life.
In the case of A.H. Khodwa and the state of Maharashtra, in a government hospital, a towel was left in the peritoneal cavity of a woman. And they went against it, and because of the principle of, I'm so sorry, because of the principle of res ispa loquitur, the hospital and the doctors were both guilty of negligence and were held liable.
When a complaint is filed against a hospital or a doctor by any court of law, before issuing this to the doctor or the person concerned, another group of people, that is a committee of competent doctors or a committee of anyone who have the qualifications enough to judge this particular act, they are asked to observe this particular situation. And after they observe this particular situation, when they have given what they think is the right or action against this, that is when this issue of negligence will be given to the concerned doctor or hospital. It is ethically true that doctors are supposed to give in their best while treating a patient. And of course, even professionally, they are bound to do so because of the Hippocratic oath they undertake in the initial days of their profession. However, we tend to overlook the fact that criticizing a doctor, blaming a doctor, even before he has been proven guilty by the court in these cases of medical negligence, is basically playing with the psychology and the mental state of the doctor. How can we expect a doctor to give in his best when the fear of prejudice, the fear of a court trial, the fear of failure, and the fear of criticism overpowers his loyalty and his skills towards his profession?
Discretion being the better part of valor, a medical professional would feel better advised to leave a patient in a terminal state to his own fate rather than taking the last desperate step to save his life and then later facing the criminal repercussions.
In this case, which is given to us in the case study, it is very easy to blame the doctors because the doctors were unable to come on time and a lack of and the inavailability of operation theater beds. But we also need to look that the DSA machine, which is in question in the case study, is a very expensive, complicated, and time-consuming machine. In this case, the machine was unable to function when the patient needed it most. This caused the patient to go through suffering, and this was beyond human control, as machines do not have the same working procedure that humans have, and it is beyond our control.
Granted, no fault is actually attached to the hospital when it comes to the vacancy of operating rooms. You cannot presume a room will be vacant just because you need it at that particular time. There are still limits to that. There are only so many rooms that can be available. But in spite of treatment, there is still the chance that the patient will die. And it is not the doctor's fault because even after giving their best efforts, they cannot deny the inevitable, that is death. And we cannot ignore the fact that there were ways that the hospital could have actually remedied this.
In the light of the given case study, our team completely sides with the court's verdict. We totally agree that there was no medical negligence on the side of the doctor, but instead there was medical negligence from the hospital side. The hospital, in spite of knowing that the doctor was not available, did not arrange for another doctor, a temporary doctor, an emergency hospital room, transfer of facilities, and they didn't even inform the patient's family timely. Moreover, we believe that occupational and professional negligence are different from each other. Even though they are the two sides of the same coin, they can never meet each other and they only supplement each other. Thank you.
Thank you, Team D, for your presentation. Judges, please mark your scores for Team D's presentation. Team E, now you have 3 minutes to confer, and you will get 5 to 7 minutes to comment on Team D's presentation. Both teams may make notes, but Team E is the only team allowed to speak during this time. And your conferring time starts now. Team E, you may start your presentation. Any member of your team may speak, one at a time, and your time starts now.
Thank you so much, ma'am. Carl Jung said, and I quote, "The medicine can treat diseases, but the doctors can treat patients." Good morning, honorable judges, respected jury members, and the esteemed audience present here today. Team E would like to take the opportunity to highlight on the case study which revolves around medical negligence. First, foremost, thank you, Team D, for your intelligent and a very good presentation. But at the same time, we would just like to say that we as a team would like to continue on the points that we somehow thought that you did not ponder upon. The specifications were somewhat missing. So, respected audience, we would like to gather your kind attention to the fact that we as a team believe that before commenting on the ethical issues of the case study, it is of utmost importance that we all are very clearly aware what happened on 23rd of April 1998. For the same, I'd like to take you all to the early 1990s. Early 1990s, where a man named Ganesh, who was suffering from severe leg discomfort, was undergoing treatments throughout the nation, and finally, he decided to get himself admitted at the Bombay Medical and Research Center on 12th of April 1998. After 12 days of his admission in the hospital, Dinesh underwent his first surgery, which was a success. It was led by a team, it was done by a team which was led by Dr. Somaya, who was the lead surgeon. And after the first surgery, which was completely successful, the patient was later, on seeing his stable condition, he was shifted to recovery. Then at 4 a.m. the following morning, the nurse called the doctor on duty, as she noticed that the patient's lower limbs were going cold. At 9:30, as you all stated, the doctor arrived. Doctor who arrived at 9:30 was again Dr. Somaya, who was the lead surgeon. When he came, he started the whole process of re-exploration. And then at 12:30, the Dr. Somaya suggested that a digital subtraction angiography test should be done, which is also known as a DSA. But unfortunately, at the time, the DSA machine was not working. So as a substitute, and another angiography test was conducted at 12:30 p.m. on the very same day, which was 24th of April 1998. The results of the angiography test came at 3:30 p.m. on the same day, and the second surgery, which was done to remove the clot, which was stopping the blood flow in the body of Dinesh, was conducted at 5:30 p.m. on the same day. And even after the second surgery, Dinesh was seen to be in a very stable condition, and even his infection after his surgery, when the doctors used to come and see him every day on regular checkups, it was seen that his infection was improving. So we cannot say that there might be a case of medical negligence. And I would just like to ponder on what you said, that during the time period of 4 a.m. to 9:30, when the doctor came, the patient was left without any medical supervision and no doctor attended. We as a team would like to disagree to this, because in the links which were provided, it was very clearly stated that at 4 o'clock, the nurse called Dr. Somaya, but before that, the on-call doctor was already present. He had inspected the case, and after that, before Dr. Somaya came at 9:30, Dr. Kriplani, who is a nephrologist, had already attended the patient. I would like my peer, Ashmit, to continue.
Thank you, Nandini. Team D, that was indeed a very well articulated presentation. But I would like to respectfully disagree here. From your speech, it was unclear what your team's stance was, because one of my learned friends said that there was a clear case of medical negligence from the side of the hospital. But then one of my other fellow peers also said that they agreed with the Supreme Court judgment, which clearly said, the two-bench judge bench clearly said that, and they refuted any case of medical negligence. So here your points are quite contradicting. Now, I would like to add on to my peer Nandini's speech. The digital subtraction angiography machine was one of the 4 machines then in the whole city. So the immediate repair could not have been pursued due to, say, lack of spare parts. So, and the doctors were quite prompt in pursuing an alternative medical plan. They conducted an angiography which showed an abdominal clot, and then the operation was successful. Now, we as a team, we consulted a host of medical professionals to understand how this treatment of gangrene was done in 1998 and also to get qualified advice. And they all said that gangrene is not a life-threatening case. I mean, most of the cases are not life-threatening. And the cases of gangrene are not given precedence over, say, other more serious cases such as code blues or cardiac arrests, which might have been in the operation theaters that day. Now, the operation theaters were busy that day, and that is no grounds for saying that there was medical negligence on the case. The hospital can only provide that many operation theaters that the hospital patient load warrants. Now, I would like my peer Hanuk to continue.
Thank you, Ashmit. Our honorable, respected, and apex, our Supreme Court held that no doctor can be held guilty of negligence just because the patient has died. In spite of the treatment, if the patient has not survived, then the doctor must not be blamed, as even with the best of their expertise, they cannot prevent the inevitable. The National Consumer Commission in 2010 invoked the principle of res ipsa loquitur, meaning medical negligence, which was ruled out by the Supreme Court because it has some factual and legal errors. We as a team firmly believe that the doctors did their job diligently. It is not possible for the doctor to sit beside the patient's bed throughout his stay. The appropriate care didn't lack in this case. So there was no sense of negligence as confirmed by our Supreme Court. Thank you. Now I would like Ekta to continue.
धन्यवाद हनुक। चाहत है उनकी सबसे अनमोल, दूसरों की जान का समझते हैं मोल, जी जान लगा दूसरों को बचाते, नहीं है उनका कोई तोल। हमारे दो प्रश्न हमारे विज्ञ मित्रों के लिए हैं। प्रस्तुत मामले में डीएसए यंत्र का आदेश सुबह 9:30 बजे दिया गया, लेकिन यंत्र में खराबी होने के कारण 3 घंटे बाद दोपहर 12:30 बजे वाहिका चित्रण का आदेश हुआ। यह जायज कैसे है कि अगर अस्पताल को यंत्र खराब होने की जानकारी थी तो इलाज के महत्वपूर्ण 3 घंटे बर्बाद क्यों किए गए, और अगर अस्पताल को इसकी जानकारी नहीं थी तो क्या प्रबंधन को गैर जिम्मेदार नहीं ठहराया जा सकता?
Your time is up, Team E. Thank you. Judges, please write down your scores for Team E's commentary. Team D, you have now 3 minutes to confer, and your time starts now.
This case study is just a snapshot. Kind of almost like.
Hello, hello.
So it has like multiple things.
Hello, hello. Mic check.
Okay, Team E. So you have 5 to 7 minutes to respond to Team E's commentary and questions. Please remember, Team D is the only team allowed to speak during this time.
Thank you so much, Team E, for such a beautiful comment made by your team. The questions were indeed worth pondering over. I feel disheartened to learn that there was a misconception and you perceived our team's ideology to be contradictory enough. However, one of my teammates did mention one of the case studies of Mr. Harjeet Aluvia, if I'm not sure about the name. But yes, and that was when the Supreme Court did held
the institution guilty and the doctor guilty for medical negligence. It was not related to the case study mentioned or given by the school. And also, I would like to say that gangrene is not life-threatening, as you mentioned. Firstly, we need to understand that human body is full of wonders. We are no one to decide which disease can actually kill us and which disease cannot kill us. Our fate, our life is very unpredictable. You never know which path your body or your entire mechanism deviates to. Also, talking about the 4 a.m. to 9:30 a.m. Controversy, who are we to decide that the doctor actually had the opportunity to show up to the hospital but did not do so willingly? We cannot presume this. And in fact, I would like to just tell you for your kind information that in any case of medical negligence, you have a proper committee of high qualified doctors sitting there, and they do dig deep into the matter. So if the government and the court did come up with the fact that there was no case of medical negligence, I am sure that the committee must have found something to support that. Thank you.
Now, to add on to that, I want to bring to light something known as the Caparo test. The Caparo test is a test that is taken into consideration when you're talking about negligence or medical negligence in general. There are three concepts to it. Number one is the foreseeability. Did the people involved in the case, were they able to see, were they able to understand that this was a part or this was the result that could have happened if this particular state was, in motion, and if they could have done something about it, did they? The second is proximity. How close were they, or how close were they to anyone involved in that case? How far away were they? Were they involved directly, indirectly? Was it the doctors? Was it the management? Was it the HR department? That comes under proximity. The third is just and fair. This basically iterates that the entire situation, especially considering the doctor in this case that you mentioned, was his situation right? Is his state justified and fair? This is the Caparo test. Now, you have reiterated all of our facts and that we have talked in our speech, and I think there was a misunderstanding of the way you perceived our speech. We have clearly said that we support the Supreme Court's verdict. That means we agree that the doctor was not medically negligent, but the hospital was. The hospital had enough time to make other measures. They could have facilitated a transfer of the patient to any other facility as well.
To quote from our speech, we clearly mentioned while summarizing all our points that we as a team support the verdict of the Supreme Court, and we believe that the institution, the medical institution, is the one that is being negligible here because of all the measures that it could have taken. It could have shifted the patient, and moreover, it is clearly mentioned in the case study that the relatives were not told about this timely, that they were not, they did not have the facilities provided to take care of the patient.
To answer your question about the DSA machine, it is a well-known fact that a doctor treats a patient, but it doesn't mean that the machine is also his own responsibility. Every machine has its own technicality, and there are qualified technicians who take care of that machine. The doctor's role is to use their help to treat the patient. In the given case study, the DSA machine was not available for use when the patient needed it the most. This caused suffering to the patient. And the blame for this does not go to the doctor. The blame for this goes to the hospital management. Because of their ill management, the machine was not ready when it was required, which is why the patient had to go through the suffering.
I would just like to reiterate my team's ideology on the question posed by you. The management, as you said, the Prabandhan, can the management be held responsible for this? And yes, we did mention it towards the end of our presentation that this is not the doctor's fault, but yes, the medical institution could have been held responsible to a certain extent for the mishandling of the machine, as you said. Thank you.
Team D, are you through with your presentation? Thank you, Team D and Team E. I must say it was a thought-provoking discussion by both the teams. Judges, please write down your scores for Team D's response. Thank you. It's now time for judges round. Okay, judges, each of you may ask one question and one follow-up question. Judges, would you like 30 seconds to confer, or are you ready to ask questions now? Yes, if you want, you can confer.
A very good morning to the esteemed guests and my dear children, both the teams. I think both of you spoke very brilliantly. So my question is, I think both of you are aware with the res ipsa loquitur word, right? It is a Latin word. And for those who don't know this, it defines things or accidents. They all speak for themselves. There are three elements of res ipsa loquitur. First is the event that caused injury to the victim would not have occurred if someone had not acted negligently. Second is circumstantial evidence rules out all the possibility of the fault of the victim or the third party. And third, there is a duty of care that an individual has towards the victim which he has breached. So what do you feel? Can the elements of res ipsa loquitur be applied to the medical negligence in this case?
Team, as you know, no conferring is allowed in this round. You are requested to respond to questions asked by judges immediately. I hope question is clear. Okay, go ahead.
Hello, ma'am, am I audible? Hello, yes. Thank you, ma'am, for your wonderful question. That is very thought-provoking. I absolutely adore this question, honestly. And the thing is that we did mention res ipsa loquitur in our speech. And the reason we mentioned is that we think it is applicable in this case. And it does have a direct application. And I absolutely think that a lot of places, it is applicable in a lot of places in this particular case study as well. And we also gave you examples of other cases where this is also applicable. And all in all, we iterated the fact that this is applicable in a lot of places with similar situations but varying results. And yes, all three of those factors are applicable, and they are also in hand with the Coparo test, which I think is very brilliant. And they will go hand in hand, and any sort of situation that has negligence involved in it will have both of these go hand in hand. So yes, absolutely.
Thank you so much for that thought-provoking question. Thank you so much for that thought-provoking question, ma'am. I would like to say that yes, res ipsa loquitur is a very good scheme, and in terms of medical science also, it can be applied. As we mentioned in our presentation, the Article 226, which is used to file a case against a doctor or an institution when the patient feels that there has been a case of medical negligence, the patient is required to go through the similar cases where he or she has to decide what was the cause of his suffering. He or she also has to decide if it's really the fault of the doctor and the institution, and they have to decide that if the doctor has breached his or her the duty to care, which every doctor has, that they will care for every patient regardless of caste, creed, religion, to the maximum and the best of their abilities.
Ma'am, moreover, I would like to reiterate from our speech, as we mentioned the AH Khodwa versus the state of Maharashtra case. Here, the res ipsa loquitur was applicable, and both the hospital and the doctors were held guilty. And I think this is absolutely a necessary thing which should be more prevalent in times like these.
Ma'am, I feel that res ipsa loquitur is an ideology of wisdom and is actually applicable to any daily life example as well. Very often, you tend to take out some household appliance, be it a mixer or be it any other appliance from some corner of your house, and you find it not working. Why? Because you probably did not have a regular check on it, that is my machine working properly or not. You must have forgotten it over the weeks and months, and it ended up not working. Similarly, in the case of the given case study, event that caused injury would have not occurred if no one behaved negligently. If the management would have taken it on themselves that to actually check the machines regularly every now and then, probably the DSA machine, which was not working on that day of mishap, would have been avoided. That could have been prevented. And that is why, as a team, we did mention that we do believe that the medical institution was responsible to a certain extent. Thank you.
Thank you, ma'am.
Thank you. I would like to request Dr. Pranay Oswal to please pose a question to Team D. You can use mine, sir.
Well done, Team D, and congratulations for putting forward all your questions. However, I see there are 6 members in your team. Sanyukta, Daksh, Bhumi, Niharika, Anushka, and Agastya. I could only hear 4 voices. 2 voices were missing, I believe. All right, great. So my question here is, did you all read the case study? Sure. Did you read? The case was actually filed against the doctors or against the hospital? Correct. So why were we actually discussing about the hospitals in the first go, right? The second thing is, don't you think it's also the responsibility of the family, because the heirs filed a case of medical negligence against the doctors, right? Initially, the patient was actually brought to the hospital because it was an emergency. This definitely means that they took some more time, that they were buying some time for second opinion. They were buying some time for maybe their mediclaim wasn't getting approved. Maybe they were actually looking out for better doctors. Definitely, they trusted in this doctor. They knew this could have been the best doctor for this patient in this case of gangrene, which I was surprised when Team E also said it's not life-threatening. It is life-threatening. I think Ashmit or Nandini, one of you all mentioned, or Hanova. Yeah, so it is definitely life-threatening, because if you do not take care of it at the right time, you can be.
Sir, one of the medical professionals we consulted said that it is not life-threatening because the patient does not die within 6 hours of the diagnosis.
You can assured, I'm a son of a doctor, so I can tell you it's pretty much life-threatening.
Sir.
Anyway, that's not a problem. My question to you is from the ethical standpoint is it right from the patient's family's front, all right? Because there are different angles. One is the patient, second is the doctor, third is the management, and fourth is the one who's actually complaining, because the one who is complaining is actually going through the real pain. He is going through the process of thanatophobia. What is thanatophobia? Thanatophobia is the fear of death and the process of accepting death of your loved ones. So he's the one who's going against, because the one who's gone is gone now. So now, don't you think he's also irresponsible in some way, because he was also delaying the treatment? Ethically, is this correct? Because don't you think this could have been much better the case? I mean, had it not been delayed so much? That's my question for you.
Thank you, sir, for that question. This is actually a topic that we have pondered. This was actually the first question we pondered over when we received this case study. And ethically speaking, it was very wrong of the family to not ensure that he received his treatment on time. And what we believe is that on the family's front, one of the major reasons they appealed for this case in the first place was their high emotions, because they didn't, assume the fact that the family member could actually die. And when the family member did pass away, as is written in the case study, they went through the phase of denial, all the stages of grief, and then they applied for this particular case. It was brought to the Supreme Court, and in the end, it was quite confusing because they wanted the thing against the doctor, but in the end, the hospital was found negligent instead.
Thank you so much for your question, sir. To answer to your first question, yes, I do believe the case study was majorly focused on the doctors. But so where the legal procedures which happened in the past, where they end is where the ethics begin. Yes, we do believe that the case study did not focus on the institutional aspect, but we did want to, put forward our ideology, because we did ponder over it, and we did come across the conclusion that even if the doctor was not responsible, the management could have been responsible, and that is the only reason we thought of putting it forward. And to answer the second question, yes, sir, I completely believe that the family members were pretty much nonchalant towards this issue, and this happens very often even in today's lifestyle, because most of us are not aware of which diseases are life-threatening and which are not. Even if we start seeing some rash on our skin, we will assume that a mosquito had bitten us last night instead of actually figuring out what it is. That is because we are very much, we do take our human body for granted. This is because of the lack of awareness, and I do believe that the family members were responsible on their part.
And sir, I just wanted to clarify one thing. You mentioned why we were discussing hospitals instead of the doctors, right?
Yes.
So a doctor is part of the hospital institution, but the hospital has a bigger jurisdiction than the doctor. They have better influence on matters regarding machines, whereas doctors are generally related just to what they are, the life science. Their job is to treat patients and to ensure that they do their duty morally and ethically. But a hospital has many different sections in it. There is an HR department. There is a board of directors. Everything. A hospital is not just the doctors. A hospital is everyone. It is from the janitors. It is from the people who clean the ACs, who clean the operational rooms, ensure the sanitization of everything around. It is all of them. And I know it's a little weird that I'm stating this right now, but it is important to know that the hospital has bigger jurisdiction in general than a doctor does. A doctor is merely an employee, but the hospital is the employer. And the employer's job is to ensure that the employee is not put into such a case where they are considered negligent, because in the end, you all supplement each other. Your job is to ensure that both of you all have a holistic development, either in the form of career or in the form of a reputation, because reputation comes first. Everyone knows that. People will choose a doctor who is more reputed from a better reputed hospital. And why are we discussing hospitals, sir, is because, as I've already said, the doctor is a part of that institution. And since that institution is a part of the doctor himself, we cannot ignore that fact. And in one of the links given with the case study, that is the elaborated information about this particular case, the team of doctors, that is the committee that was referred to, was asked to specifically talk about whether the hospital should be involved in this particular case or not, and they agreed to that. So that is one of the reasons why the hospital was involved in this particular case.
Great.
Thank
you
you,
very much,
Team
Team
D.
D. Thank you very much.
Now I request Advocate Shailendra Aglavi to pose his question to Team D. Thank you, sir.
Okay, so there's one thing which I hope I'm audible.
Yes.
Yes. Okay. There's one thing which I noted in this entire discussion is there is a drift to this discussion towards having a review of the judgment which is already passed. Okay, the Supreme Court has already given its verdict. They have given it their finding. So the case is closed. Now, in this entire discussion, there is one thing which I noted, that more of the discussion was whether there was a negligence and what are the facts. So it is like revisiting the facts which were involved in the case to justify or to oppose the ultimate verdict which has already come. So now a Supreme Court judgment is that we cannot deviate from it. What I am expecting from you, and the question which I am putting to you, is the aspect of negligence. Now, negligence is both a factual aspect as well as an ethical aspect. We have already dealt with the factual aspect. The courts have already dealt with the factual aspect. 1, 2, 3, 4, 5, 6, 7, 8 facts. 1, 2, 3, 4, 5, 6, 7, 8 evidence, whether it proves that there was a negligence or not. So this is factual aspect done. But what I am expecting, there are two aspects to my question. One, she has already put that whether that principle of res ipsa loquitur can be applied. You said yes, it can be applied. But what I am expecting from you now, after answering that, is why do you say that it should be applied? So I want a reasoning from you, a logical reasoning for application of this principle. See, res ipsa loquitur is a principle or a rule of evidence. What it says that what you can conclude from the base facts whether a thing has happened or a thing has not happened. So it is a rule of evidence. If one thing exists, whether the other thing exists, what you have learned in logic, derivative and all those sorts of logic which you have learned. So that is the first part of it. I want your reasoning for application to it, because in case of accident cases, in case of in many other cases, suppose for example, a manufacturing defect in some product which has resulted into some loss to a person. So if the defect is in the manufacture, it is evident that it is a negligence. But in medical cases, the standards are something different. The relationship is something different. There is a relationship of trust between the doctor and the patient. So can you set up such standards which can give a clear-cut distinction between, yes, this is negligence and this is not negligence, as in case of goods and products and services? Yes. So this is one aspect to it. Now, second aspect to it, you talked about the Hippocratic Oath. You talked about the relationship between doctor and patient. There is one important thing in the Hippocratic Oath, that the doctor should treat the patient with best of his ability. Right? Now, what is this concept of ability? Ability of one person, ability of one doctor may differ from the ability of another doctor. Besides this ability, I propose to you two more concepts. One is the concept of capacity, and second is the concept of availability, which have been involved in these particular cases. So, if a person comes to a doctor saying that I want to be treated, he is a doctor who has done his basic graduation and who is having his own clinic, a small one, with some assistance or with no assistance at all. Now, the level of ability which that person would be having and the level of ability of a doctor who has had much more experience and exposure to more complicated cases is different. Then comes the aspect of capacity, right? How much a person can work in a day, because doctor also is a human being. How many hours of work he can put into is definitely limited. After say 8, 10, 12 hours of work, his capacity to go on with it may be reducing. It happens with everyone. 2 घंटे पढ़ाई के बाद हमें बहुत हो गया ऐसा लगता है ना, होता है ना? So that is one aspect of it. And third aspect is availability. So he being a human being, he has his own restrictions of timings. He has his own life which he has to live, and he has his own profession. So my question to you is, this aspect of negligence of a doctor or negligence of a professional is dependent or should be dependent on what? Whether the standards which, besides his professional bodies, some other bodies are deciding upon, say a consumer forum, say a civil court, say a criminal court, who are not experts in the field, but they are the ones who are deciding upon his negligence. Will be they the right person to decide upon these standards? Or what decides the negligence? Whether it is the expectation of a patient from the doctor. So whenever a patient comes to a doctor, he expects that he should be available. I'm not ill, so I don't bother what is your personal life. You are supposed to be committed to your profession 24/7. So this standards of performance, this negligence in performance of the duty is to be dependent upon what? This is the ethical aspect to this problem. Okay, So, and there is one more aspect which you dealt with, is about the contract, is about the relationship, is about the implied undertaking, and the essential elements you discussed about duty to patient, breach of duty, and harm to the patient, right? Now, there is one more ethical aspect which I want you to think about. You may not answer it right now. There is, while Supreme Court giving this judgment that nobody can guarantee that he will survive, no doctor. Now, to what extent it can be stretched? Death is inevitable. It's a hard reality of life. So, how do you decide again? The question comes back to this. How do you decide again about the standards of performance for a professional? And the contract aspect which you dealt with, whether really it is a contract. I don't know how much you have learned about the concept of contract, the meaning of contract under law. But if you say it is a contract, then the liability of the contractual parties are only dependent upon the contract and nothing more than that. So what has been the contract, what do you say is exactly the contract between the patient and the doctor? So whether it is something more than what is his own professional commitments or something more than that. Any doubts about my question? And there's one thing I would like to tell to both the teams. I welcome your questions. So I would be glad if you have questions besides we having questions for you. Yes, we are going to judge your abilities to answer it. But as I told in the last round also, if you are having more questions from the questions we put up, from the case study which you have put up, that is a good sign. You may not be able to answer every question, but if you are able to put more questions on the questions, that will be a good sign. Yes.
I hope questions are clear to Team D. Team D.
Sir, actually, the last part of your question regarding the liability of contractual parties, we didn't quite understand what you wanted us to answer.
Yes. See, whenever there is a contract, there are two parties. One promises something, the other one accepts that promise. So this is the basic meaning of the word contract. So I want you to explain to me, when you use the word contract between the doctor and the patient, what is that promise which each party is giving to each other? And if that is if contract is your base for argument, why not the liability of the contracting parties be limited to the contract? I am going to treat you, I treated you. Now, whether I treated you to the best of my ability and what is exactly my ability should not be the question which can come up if it is a contract.
Is it clear, Team T?
So to reiterate your questions, one of your questions is what we need to do is explain a contract and what it is that it promises, and why not liability be limited to the contract. And the other question that you ask is why res ipsa should be applied.
Yeah, so in short, I asked you three questions. One was her question. I just wanted you to go to a logical end of telling us the reason for applying that. Second was, what decides the negligence of a doctor? What are the standards of performance? Who decides them? Whether it is the patient or whether there should be someone else. And the third aspect was about the contract.
Okay, Team D, you can go ahead and answer the questions.
Thank you so much, sir. Very deep questions. I must appreciate your questioning ability. I really praise it. So, sir, one of your questions was, should the term negligence depend on the ability or the skill of the doctor, if I'm not wrong? So I believe negligence does not depend on the skill, but rather it depends on the fact that is the doctor concerned at that time utilizing his skill to the maximum limit? Is he actually giving in his best? We all humans, doctors are humans at the end of the day. We all have different abilities, different limits, different talents. Negligence is not about you not being able to cure someone because you are not capable of doing so or you are not born with that talent. It is about you were born with that talent, but you did not make the efforts required to utilize your talent to treat the patient. So that is negligence. So I do not believe that negligence depends on your skill or your ability, because even as a patient, if I am going to a doctor, I will never ask him if how much marks did you get in your MBBS, or how well did you pass, or did you get a retest, did you repeat your year. I am trusting that whatever this person is capable of, I trust you that if I am walking into your clinic, you will treat me with whatever resources you have, with whatever knowledge you have, with whatever talent you have. This is the contract between me as a patient and my doctor.
Why not liability be limited to the contract? Sir, this may be a weird example, but let me give you the example of Merchant of Venice. Merchant of Venice is a play written by William Shakespeare, and in that, there is a bond between a Jew named Shylock and a Christian named Antonio. Antonio did not have money on him, but he needed money to lend to his friend. Both of them are money lenders, but the difference is that Shylock takes interest for his money and Antonio doesn't. And Antonio, in that particular case, did not have any money on him, and he needed to lend money to his friend. So he appealed to Shylock. And Shylock said, absolutely, we both have the same, we both work in the same area. I know what you feel. I will absolutely give you the money. But in return, if you don't give me the money back in this amount of time, I will take away a pound of flesh from your body. Sir, in modern times, we may not use these exact terms, but the terms of a contract are definitely this extreme. But when it comes to a doctor is believed to be someone who is close to God, someone who has the ability to give life, someone who has the ability to cure you of diseases. And when it comes to a contract between the doctor and the patient, both of them honestly have a lot to lose and both of them have a lot to gain. There is a liability on both sides. And it definitely must not be limited to just them, because in the end, both of them are human beings and they need a collective bigger decision that is taken on by the government. The government provides an unbiased solution to all of this because there exist laws and laws govern these. So liabilities always exist and liabilities are a part of a contract. But in a contract, you cannot depend solely on the people involved. There has to be a third party that is unbiased.
Sir, to answer your question about the contract to reiterate my team members' answer about the contract between a patient and a doctor, she said that it's based on trust. And sir, it's very true that it's based on trust. I would like to take an example here of a chapter I had in my English book, English literature, a few years ago. It's named The Birth. Sir, in this chapter, the doctor, he's a novice doctor, so he doesn't have a lot of experience. He helps a mother, a mother who was giving birth to a child for the first time after a very long, they needed a child for a very long time. So this was the first child and they were very worried about it. So the doctor helped them in their first child. The child was stillborn. The maid was worried and shouted that the child is a stillborn. The doctor here could have said that, ma'am, sorry, your child is stillborn, and the thing could have closed over there. But the doctor went through did a complex procedure where he revived the child using hot and cold water, and the child was revived. So this is an example of what a relationship between a doctor and his patient is, where a patient is revived from certain death. A stillborn child was turned into a living child. This is what a doctor does. And this is why the relationship between a doctor and a patient is one which is of the highest order.
And sir,
when it comes to setting up standards for these kind of things, it is not right to set standards when you're considering individuals. If you consider a job as a whole, yes, you absolutely can set standards. As a doctor, you have a duty and you have to do everything within your ability, your skill and knowledge to perform that duty. But when you are considered an individual, you are still human. You may have a duty, but you are human. You need that rest. You need to, take a chill pill. You need to breathe. You need to have that ability to unwind. And sir, let's look at the case study itself. There could have been a case where the doctor who was called at 4 a.m. was somewhere else, and due to unknown factors, he couldn't have made it there on time. So there is a second aspect to look at here. The doctor would feel guilty about this. His patient needed him there, and he was not able to go there. This is not negligence per se on his part, but rather his inability to do his work. There is a difference here. Why? Because negligence is him doing it either via laxity or him being careless about it, but this is not carelessness. This is a serious situation that no one could have predicted, because gangrene is a very, very unpredictable disease. And in this particular case, it is very different because there are so many aspects to consider here, and setting up standards should be done only when you're considering professions in general, and setting up standards when it comes to, a person, considering a human being is wrong and unethical. You cannot expect a person to work 25 hours in a day. That is not possible. And you also revisited the facts about this case, sir, and I really appreciate that. And there's only so much work a person can do in a day. It does not matter whether it's a bad day or a good day. They will still do their best, to the best of their abilities, especially if they believe in the profession that they are in. They will do absolutely everything they require to make sure that everyone involved in the contract, them and the second party, as well as the third unbiased party, is happy with everything that is happening. That is the point of a contract.
So this was a very mind-boggling question, and it really made me think. Sir, I would really like to know your opinion on this question, since it's more of a conversation.
Good.
Because,
Good.
sir,
I was
your
expecting-
perspective is very interesting and unique. And
That makes you a very smart team, right?
See, there is, I'll give you an example. It happened few days back with one of my neighbor. She was 80 years old, and her BP dropped suddenly. She was at home. Her BP dropped suddenly, her pulse dropped suddenly. And I, as a layman, was trying to contact some doctors and ambulance. By that time, I could recollect, or my wife could recollect, that there is a nurse staying near us. So we called her. And we also recollected that there is a doctor nearby. So I sent someone to call that doctor. Now that doctor is one who has his clinic in a slum area. Okay. So he doesn't have much of an experience as a doctor, I would say. So maybe I'm not questioning his ability or his qualification, but maybe he didn't have that he didn't have that confidence to face this situation. So when the person went to that doctor, he said that, no, I'm not in a position to come. I mean, I can't handle this. Okay, so he didn't come. The nurse attempted CPR and all that. But by the time we took her to the hospital, we reached the hospital, she was no more. Now I'm looking at this situation on these principles which we discussed: stability and capacity and availability, right? The standards of performance, or the professional performance which are expected from doctors or lawyers or even teachers, for example, they are not so well defined to have a very scientific checklist. Yes, this is done, this is not done, this is done, this is not done. Yes. So here, but what is expected is that they should upgrade their level of knowledge. So a lawyer, whenever he's arguing in the court, if I'm putting before the court at some point based on some previous judgment of Supreme Court, High Court or something. Law is a dynamic thing. So what I refer to the judge, he might come up with, or other party may come up with, no, this judgment is already overruled. The law has developed to this extent, right? So if I am doing that, if I am putting up a case which is bit older, and I have not been able to get the updated knowledge on this, I may not be a professionally negligent person because I have attempted it, right? Finding out some updated knowledge is an attempt. So what matters really is the attempt to do it, right? So what you rightly said, that giving the best of his ability. Now my ability may be restricted, but my approach need not be restricted. My attempt need not be restricted. My try may not be restricted. Now we see there are so many honorable audience who are working in the army. They might have faced this situation. The doctors working in the field. What are the equipments and medicines which they have at their hand who are working in the field is so limited. But so those equipments and those medicines limit the ability of the doctor, right? How much he can treat is a limitation. But what he does is his attempt to do the best by whatever is available with him. Now again, medical field is also develops every day. So what medicine is good today is harmful, it's poison tomorrow. So in Corona times, remdesivir was supposed to be the life-saving, and by the end of the year, it was supposed to be a not to be used medicine, right? So if a doctor is abreast with him, with his knowledge, he's attempting to do it, that is what is the expectation. Oh, yes, expectation of his fraternity, the expectation of the patient also. So this is what the courts have to look into while deciding upon the medical negligence cases, right? So I hope I'm clear on this aspect. Yes, anything more? Yeah.
Sir, I actually have a question regarding this. You have talked about attempt, and one thing that we as a team wanted to talk about was the intention behind it as well. Now, what you do and what you attempt to do may be different from your intention. So, sir, in these cases, how do you know that the person was attempting to do something else and his intention was something else altogether? What if the intention was contradictory to his attempt?
This is one thing. Whenever you go to a doctor, what exactly makes you decide that, yes, I'm ready to get treated by this person? Yes, whether they are the qualifications, whether it is the nature of the clinic which is the deciding factor, or your actual interaction with the person and your feedback from others who have been treated by that person. Yes, so I think both of them. So if you go and talk to a doctor, he gives you what impression he creates in your mind. भैया ये तो कुछ नहीं हो सकता, हाँ, ये एक रिएक्शन होता है. दूसरा रिएक्शन होता है कि कोशिश करके देख सकते हैं. तीसरा रिएक्शन होता है आप चिंता मत करो. हाँ, so what he gets out of you is that fear. Neither of these three situations, he is assuring you that you will be good or you are going to survive. Neither of these situations. So much depends upon your own assessment of that particular professional. So when you are going to select a doctor, when you are going to a doctor for your treatment, you are assessing the abilities of that particular person. Now, how do you assess it? कुछ लोग गूगल पे सर्च करके करते हैं, हाँ ये दवाई दी है, ठीक है देख लो. So that's a cross check which you are doing. You take a second opinion. You listen to the experience of those who have been treated. बाजू वाले से पूछ के देखते हैं भैया इसका दवाई ठीक से देता है ना, तो These are the various methods. So what is important is that your assessment of the professional is very important, right? So that contract aspect when we are discussing about. So this is the another part of the performance. In any contract, there is an aspect of buyer beware, caveat emptor. This concept you'll come to know when you learn law. So whenever you are buying a product, you are supposed to check it. ठीक ठाक है कि नहीं, टूटा फूटा तो नहीं है. तो ये आपकी रिस्पॉन्सिबिलिटी है देखना. तो इसी तरीके से आपके प्रोफेशनल की एबिलिटी क्या है, कितना कर सकता है, ये आपकी रिस्पॉन्सिबिलिटी है. दूसरा एस्पेक्ट है the professional himself knowing his abilities. So if a person who is not experienced in the field, a patient comes to him taking the decision ki no, I am not in a position, admitting this fact that I am not in a position to treat you, I don't have that ability to treat you, is also an important thing. So you need to go to an expert, you need to go to a specialist. This is what is also expected from any professional. If a case comes to me, if I am not in a position to give time to it, I should be able to say to him कि देखिए भाई मेरे पास वक्त नहीं है, मैं आपको टाइम नहीं दे पाऊंगा, आपकी केस हैंडल करने की मेरे पास अभी कैपेसिटी नहीं है, इस टाइप के केसेस मैंने हैंडल किए नहीं है, ये मेरे फील्ड ऑफ वर्क नहीं है, ये बताना पूरी ईमानदारी से, ये भी बहुत जरूरी होता है. दिस इज ऑल्सो अ लेवल ऑफ परफॉर्मेंस विच यू एक्सपेक्ट, राइट?
Thank you, Team D. It was indeed a gripping discussion. Thank you, judges. Now I request you to please quote Team D's responses to your questions. Participants, with this, we have come to the end of round 1. I now declare 15 minutes break before we begin the Team E's presentation. Thank you, everyone. We will meet after 15 minutes break.
Ethics Board rewards critical thinking, collaboration, and improvisation. And it covers all the 6 competencies of students. It's a great way for students to deepen their philosophical understanding. The event under the aegis of Southern Star Hour was conducted by APS KIRKEE. The case studies were relevant to young students, such as questions concerning plagiarism, peer pressure, use and abuse of social media, privacy, relationships and responsibilities, social and bioethical issues were also included. Although the event was competitive in nature, but to promote collaboration.
चेक ये देखिए दोनों में लाइट जल रहा है चेक ये हो गया चेक 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 ये दोनों आउट चेक 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 चेक
They did not take any con and pro positions. In fact, they were agreeing to disagree with each other. It was a novel experience for all of us, and we are looking forward to the final event. Wishing you all the best to all the finalists. Thank you.
Hello, everyone. We at APS Kamraj, Bangalore, conducted the hybrid form of ethical bowl competition on 7 June. The school hosted the participants both online as well as offline, and the experience was phenomenal. Our school then went on to a series of matches with different schools in Southern Command, and in true spirit accepted to agree to disagree. Thank you.
Well, Ethics Bowl is a wonderful idea to enhance cognitive approach amongst our students, to help them come up with their views and at the same time accommodate the views of their peers in terms of all the social, ethical and emotional dilemmas. A wonderful concept to inculcate.
The Ethics Bowl has impacted me as an individual and helped me in making the right choices.
एथिक्स बोल ने मुझे सामाजिक समस्याओं को समझने में एक बेहतर नजरिया प्रदान किया है.
Ethics Bowl has sparked in me a positive sense of competitiveness, and it has taught me how to constructively discuss about societal problems.
Ethics Bowl has set new limits to my abilities. It has enabled me to look at social issues from a wider perspective.
The Ethics Bowl has helped me develop a wider perspective on topics that matter to me. It has allowed me to put forth my opinions in an environment that guarantees to respect it.
Ethics plays a major role in forming the social behavior of people. Ethics Board has helped us make decisions which have a positive impact. Moreover, they steer us away from unjust decisions.
Student community is a very vital component of any society or a nation at large. The Ethics Bowl competition is a great effort by the Army Wives Welfare Association towards encouraging collaborative teamwork and also inculcating among the students the ability to make conscious and constructive choices based on ethical standards. From small everyday activities and choices to larger, more consequential ones, students face a myriad of decisions with ethical implications or dilemmas. How do they do the right thing? And even what the right thing is. So I feel participating in this competition has empowered them to be more confident in voicing their opinions, in conferring, in researching, deliberating upon a particular case study, and that too in a very congenial manner without any display of aggression. I really want to thank our Southern Command for having given this unique opportunity to our students to participate in the Ethics Bowl competition. I wish all the best to the teams that are participating in the finals, command level finals at this. Thank you.
Good morning, Dr. Raji here, Principal APS Trivandrum. Ethics Bowl 2022. It was a well-organized program with active participation from students and an eminent panel of judges. We do appreciate the efforts taken by the entire team for the smooth conduct of the program. It was a knowledgeable session for all students and faculty. Thank you very much.
Yes. Now this is the final result. Just look at the last column. Matches won. Team A has won 3 matches over a period of 5 days. Team B has won 2 matches. Team C, unfortunately, but still they were very good. Team D 3 matches and Team E also 3 matches. So now here is a tie and we have to select 2 teams out of these 5 teams. In round robin, we thought that teams having maximum number of wins will reach the final. So now since we have 3 teams with the 3 wins, so now the next step is we have to see the score. The points which they have scored will be the deciding factor whether which team will go. Two teams have to face the final. So now, Namrata ma'am, I would just request you to show the next screen so that we can just disclose the marks. If we look at the marks scored by all the teams, Team D has scored highest marks, that is 361.5. So you're clear cut going for the final. And the second team is DE with 352 points. And that is, so we are waiting for you at KIRKEE. And heartiest congratulations, team A, B, C, D, E for putting up such a wonderful show. And all the best to all of you. And we'll be waiting for you in KIRKEE on the 1st of August. And over to Sonia ma'am, and thank you so much.
Thank you, ma'am. Thank you so much. So very well done, all of you. The final match will be played in person right here with us at Army Public School, KIRKEE on 1st of August 2022. So Team B and Team E, get ready to pack your bags and make your journey to Pune as we look forward to hosting you and witnessing the champions battle it out in the finale. Until then, take care, stay safe, stay happy.
Army Public School KIRKEE presents to you Ethics Bowl 2022.
No. Before we begin with round 2, I may request everyone to switch off their cell phones. Thank you, everyone. I would like to confirm from Team E if they are ready. Please check your mics.
Am I audible?
Yes, you are. Team E, I hope rules are clear to you. Okay, thank you. So all the best, both the teams, as we begin with round 2. Team E, it is your turn to present now. I will now read the case study. Team E, your case study is titled Conflict Between Right to be Forgotten and General Public's Right to Transparency Against Judicial Records. When Akshay Singh, an American citizen of Indian origin, came to India in 2009, a case under the Narcotics, Drugs and Psychotropic Substances Act 1985 was lodged against him. An appeal was filed before the Delhi High Court challenging this order of the trial court. Through an order delivered on January 29, 2013, a single judge bench of Delhi High Court upheld Akshay's acquittal and cleared him of all charges. Akshay soon realized that due to the fact that the judgment rendered by High Court was available through a Google search to any potential employer who would want to conduct his background verification before employing him, he faced unnecessary stigma and prejudice, which put him at a huge and unwarranted disadvantage. He claimed that the court appeals internet accessibility constituted a blemish on his reputation and requested the search engines to remove those results. This is where the right to be forgotten, one's right to remove personal information from publicly available sources, such as internet searches and other online directories under certain circumstances, gets in conflict with the right to information and right to transparency of judicial records. Team E, my ethical questions to you are, should a person's right to be forgotten be prioritized over the right to information of the general public? Should there be any obligations on the search engines regarding cases which are no longer relevant as the one mentioned above? Question number 2, can valid arguments be advanced for making the right to be forgotten a fundamental right? What those arguments could be? What limitations, if any, can it be subjected to? I hope questions are clear to you. Okay,
Yes,
Team E, you have 12 minutes to make your presentation and your time starts now.
Thank you, ma'am. Very good morning to the honorable jury, esteemed audience, and my fellow peers. Team E would now like to present their views on the given case study. Right to privacy is an inherent human right, and it is a basic requirement to lead a human life with respect and dignity. Imagine being Akshay Singh in this case. He came back from USA to his motherland and he was welcomed with a narcotics case. He was acquitted of all charges by the court and he was proven to be innocent. Alas, he won the case in court, but he lost the case in his real life. After the case, his livelihood, his career, and his personal life was lost. Esteemed audience and jury members, how is it fair that a citizen and any person loses his livelihood and his personal life just because when a person searches his name, his past cases show up, even though he was acquitted of all charges and the case might not be relevant here? Isn't it the duty of the judiciary to protect the acquitted person's right to privacy and right to life after the case has been dealt with? Well, this is where the right to be forgotten comes in. Right to be forgotten is a right where the person can remove his personal information from public domain that might not be relevant or might be outdated from domains like search engines and databases. Now, right to be forgotten has many legal precedents, one of which was of Mrs. Mario Gonzalez, who filed a case against Google Spain in the European Court of Justice. So she alleged that whenever her name is searched up, this case was filed in 2014. So whenever her name is searched up, a 1998 case of debt recovery comes up, and also her house auction reports come up. So the European Court of Justice won the case and the Google Spain was obliged to delete all of these articles. Another case was of Zulfikar Ahmed Khan, who filed a case in the Delhi High Court against the media company The Quint, who wrote 2 articles on him based on anonymous harassment case during the whole Me Too movement. The High Court clearly instructed the media company to not republish these articles and to remove it immediately. And also the honorable judge mentioned clearly that right to privacy and right to be forgotten is an intrinsic facet of Article 21, which is the right to life with dignity. Now I would like my peer Nandini to continue the presentation.
Thank you, Ashmit. The case which was mentioned by Ashmit, the case of Mario Gonzalez, it gained a lot of public attention. After the occurrence of the case, it was seen that the demand for the right to be forgotten had gone subsequently extremely high. On the data which is present on Google's official website, it is seen that the number of websites and the links and the searches which are evaluated to be deleted and are in search for deletion are standing at 1.63 million till date. Let's take the case of Indonesia. Now in Indonesia, the practice of the right to be forgotten is regulated under the Article 26 of the ITE Act. Now, what does it mean? It clearly means that the Indonesian citizens are well within their rights to ask the government, the Indonesian government, for the deletion of documents, for the deletion of data from all public domains, as long as it is irrelevant and is not at all important. Now, rules of the ITE, which are in reference and which are in reference and regarding the right to be forgotten, are done and are placed in such a way that they accommodate the GDPR. What is the GDPR? The GDPR is a General Data Protection Regulation, which is now a part of the European Union law. It is very, very important for all of us to know that GDPR in itself is a data protection regulation, and it is now being upheld in a lot of courts throughout Europe and throughout the UK. Now, considering the cases that have occurred over the years, we see and we can come to a conclusion that the right to be forgotten is an intrinsic facet, as my peer mentioned, And it is very much needed in times like these, but we should also keep the other side of the story in consideration. We should know, we cannot negate the fact that the implementation and the formulation of a policy to ensure that it is regulated properly and implemented properly, its formulation in a country like India is not easy. In fact, it is a very, very complex task. Although we as citizens have been granted the right to express our views and emotions and our opinions freely without censorship, but we also need to know that we as responsible citizens have a moral obligation. We have a moral obligation to the other party. We have a moral obligation to the other person who's standing in front of us. We need to make sure that our opinions should not hurt their sentiments. We should know that just because we are practicing our right of opinion and we are expressing our views, it does not mean that we hamper their sentiments and emotions, which would in fact come as a threat to the internal security of our nation. Then the right to be forgotten is recognized as a statutory set of laws by the GDPR and is again recognized by the union law. Let's see the case of India. Where is India standing in this aspect? India till date does not have a particular law which specifically gives the people the right or specifically justifies and tells the person to go and file the cases against on the basis of the right to be forgotten. But the Personal Protection Bill of 2019 recognizes the right to be forgotten as a right of the Indian citizen. So it can be concluded, to answer the question, it can be concluded that the right to be forgotten can be flexible and should be flexible so that fair treatment is given on case-to-case basis. Because if the right to be forgotten is absolute in nature, then what will happen is it might end up giving unprecedented advantage to one person, while the fundamental rights of the other person, the other team, is what is hampered here. Now I would like my peer Hanok to shed light on the issue.
Thank you, Nandini. Let's take an example of Ashutosh Kaushik. He's a Dubai-based businessman. He was accused of dowry and domestic violence, but he got free. He was set free because he got his issue settled afterwards. But what happened was, like, he faced defamation. He faced defamation on every search engine. A pop-up would come that Ashutosh Kaushik is a wife beater. Now, after he appeared to the court and said, I want this issue to be deleted from the database, but there was not much interference by the court. And due to this, again, this issue came into limelight. And again, people could see on the pop-ups that he is a wife beater. Now, as Shailendra sir mentioned in the previous case study, that what we as I as a person would do, that I would see the professionality of a doctor, assess the professionality of a doctor on Google. The same way, when he dealt with his clients, he's a financial consultant. When he dealt with his client used to search on Google Ashutosh Kaushik, and what they get is a wife beater. This not only affected his economically, but it even affected his social dignity. That violates his Article 21, the right that is provided by Indian Constitution. High Court is currently considering this right to right to be forgotten. High Court is considering this due to the international dependence of rights, due to advancement of technology and the data. Now, of a person, we can find a plethora of information on search engines. But this can even affect that person's reputation, and even it can violate the right that is articulated in Article 21 in the Indian Constitution. Your exposure of information is like a toothpaste. Once it comes out, it can't be put back in. Sir, we are talking ethically, so that's not possible. So the Right to be Forgotten Act cannot be a fundamental right answering the question, because it has to be reviewed case by case basis. And there are certain measures that need to be taken. There are certain exceptions, like establishment or exercising of purposes on defense of legal terms and compliance with legal obligations. There are many exceptions, but we need to think about that this cannot be a fundamental right because this had to be reviewed on a case by case basis. Now I'd like my peer Ekta to summarize the team stance.
धन्यवाद हनोक. मेरी निष्ठा का ना करो हरण, सोच विचार करो मनन, मेरे हृदय कपाटों में मत झांको, मेरे हृदय को मत आंको, करो नहीं मेरा उपहास, मेरे अधिकारों का पूरा ह्रास, समाज की मनमानी नहीं स्वीकार, निजता है मेरा अधिकार. निजता के अधिकार को अनुच्छेद 21 के तहत प्राण व दैहिक स्वतंत्रता के अधिकार के आंतरिक रूप में तथा संविधान के भाग 3 द्वारा स्वतंत्रता में संरक्षित किया गया है तथा भुलाए जाने का अधिकार एक व्यक्ति को सार्वजनिक रूप से उपलब्ध अपनी व्यक्तिगत स्वतंत्रता, अपनी व्यक्तिगत जानकारी को अंतर्जाल जानकारी संग्रह या किसी भी अन्य सार्वजनिक मंच से हटाने का अधिकार देता है जब वह अनावश्यक या अप्रासंगिक हो. हम एक समुदाय के समूह में मानते हैं कि खोज इंजन का दायित्व है जानकारी को हटा देना जो अपर्याप्त, अप्रासंगिक या अप्रासंगिक नहीं है, लेकिन ये मामले दर मामले के अनुसार होना चाहिए. उनके अनुरोध पर खोज इंजन स्वचालित कलन विधि के अनुसार अपनी प्रक्रिया जारी करती है, लेकिन वह उन पे दूसरे नजरिए से नहीं देखती. अतः इससे यह निष्कर्ष निकाला जा सकता है कि भुलाए जाने के अधिकार को प्राकृतिक रूप से लचीला होना चाहिए ताकि उचित न्याय प्रदान किया जा सके और किसी की मर्यादा के साथ ठेस ना पहुंचे. अगर यह निरपेक्ष होगा तो व्यक्ति को अनुचित लाभ मिल सकता है तथा आम जनता के मौलिक अधिकारों का उल्लंघन हो सकता है. इस प्रकार इसे इतना लचीला होना चाहिए ताकि विभिन्न मामलों का मामले दर मामले और परिस्थितियों की जांच कर संशोधन किया जा सके. धन्यवाद.
Thank you, Team E, for your thought-provoking presentation. Judges, please mark your scores for Team E's presentation. Thank you. Team D, now it's you have 3 minutes to confer. Your time starts now. Yes, sir. Yeah, right. Madhu, ma'am, can we have you on stage, please? Your conferring time is up, Team D. Thank you. Team D, you have 5 to 7 minutes to comment on Team E's presentation. Any member of your team may speak one at a time. Your time starts now.
Thank you, Team E, for that extremely enlightening presentation. It was really interesting to know your views, and I'm glad that we see eye to eye on most topics, because we as a team believe that this right should be flexible on the internet in a way that it protects the privacy of the individuals while upholding the right to information. I extremely appreciate how you justified your views with so many examples, and it was really interesting to hear.
Thank you for that well-researched presentation, Team E. I would like to commend your team's reading skills. We as a society should only exercise the right to be forgotten only when it has been proven that the person in question is proven innocent by a court, and a court which follows the rule of law. Because if we allow right to freedom to be made a fundamental right, we directly impeach upon the right to freedom and freedom of information of many people. So if we as a society will set a precedent where we may allow a sinner to get rid of his sins and escape from those.
Teamy, I appreciate your profound research on the given topic, and I have acknowledged your favoring views on the right to be forgotten. But as right to transparency emphasizes that it is important to learn about the incidents that have been happening throughout the country, so as to learn our lessons through these incidents as common people. I would like to give an example of the Kerala court, where they agreed to conceal the names of the people involved before uploading it on the search engines, so as to prevent their defamation, which is your team's main concern. And that is how they balanced the right to transparency and the right to be forgotten hand in hand. Now, my question is that since maximum utilizers of these search engines and social medias, where this information is easily accessible, are young teenagers like you and me. So how can you, as a young, responsible teenager of India, ensure that both of these rights, right to transparency and right to be forgotten, go hand in hand?
Teamy, your speech was extremely insightful, and your mention of the GDPR, taking in even the sentiments of the people involved, was amazing. And your examples were quite colorful. I thoroughly enjoyed them. When a case goes to the court and it is closed, there must always be a record of it, name and all. While the right to be forgotten can be flexible, one, there are too many platforms and search engines, so data is never truly deleted. And secondly, growing up in civics, we have always been educated about a welfare state. It basically means that the happiness of the entire state prevails over the happiness of an individual. So technically speaking, won't the right to transparency trump the right to be forgotten?
Team D, are you through with the presentation and questions?
Yes, ma'am. Yes.
Thank you. Judges, please write down your scores for Team D's commentary. Team E, you now have 3 minutes to confer, and you will get 5 to 7 minutes to respond to Team D's commentary and questions. Your conferring time starts now.